and the person moving into residential care about how those funds are going to be made available. Quite often it is a loan from the family trust to the resident that's required to be repaid when the resident dies or moves out of the unit. You also need to consider that who is going to pay the village contribution, which is the amount that the rest home takes in fees when the resident moves out of the unit that they have an occupation licence for. That can easily be 30% of the purchase price, so can amount to quite considerable sums of money. Sometimes the resident has funds available to pay for it themselves, but more often than not, the family trust needs to look at how the trust can meet that cost. And there are various options available for doing so. And it's worth talking to your lawyers about the different options before the occupation agreement is purchased. Decisions need to be made by all trustees and recorded. So you need to make sure that, particularly if the residents going into care are also trustees, that they actually have full capacity and have the ability to act as trustees. If they don't, then you need to consider removing the incapacitated trustee and also look at anyone else who might be heading towards losing capacity and remove them before it becomes difficult and expensive to do so. Once a trustee is incapacitated, it may be necessary to apply for vesting orders to enable the transfer of any trust property to the remaining trustees. Vesting orders can be expensive and time consuming, and if you already have a contract for sale and purchase, it may result in that contract falling over. So best to be considered as early as possible. Active management of the trust is obviously a very essential element of dealing with older clients. The next thing I want to talk about is income derived from gifted assets. I don't have an answer to this, but what I'm pointing out is a case that is currently in the Court of Appeal. The case is Broadbent versus the Chief Executive of Ministry of Social Development. The High Court cases are a 2017 case. The High Court was asked to consider how gifting that falls within the gifting threshold of $27,000 per annum is permitted, that's permitted under social security legislation, is to be treated when a person subsequently applies for a residential care subsidy. The Ministry of Social Development argued that it can assess income that would have been earned from gifted assets as deprivation of income. The High Court looked at the relevant statutory scheme, which is the Social Security Act, and looked at long-standing principles of common law and decided that where a gift is made, that gift is absolute, and the person making the gift then can't turn around and say, actually now I want the income that the person who received the gift is now receiving from that gift. That just doesn't stack up. So the High Court said that the Ministry of Social Development couldn't assess income that might have been received if the person hadn't made a gift as deprived income. Ministry of Social Development was a bit disappointed with that outcome, so they appealed to the Court of Appeal. The Court of Appeal heard the case last year, and we are still waiting for the decision. And until that decision comes out, we can't say any more really. But if it goes in the Ministry of Social Development's favour, it's going to cause some quite significant issues for people who've made gifts over a number, well, for long periods of time. So the answer to this one here is really watch this space. The other issue we encounter with people moving into residential care is those who have contracting out agreements. So either they have entered into a contracting out agreement at some stage during the marriage, or are in a second relationship and have a contracting out agreement with a new partner, which is quite common where couples wish to protect certain assets for their own children. The problem we have here is that the Ministry of Social Development does not recognise contracting out agreements, even if they comply with Section 21 of the Property Relationships Act 1976. So they assess asset and income for residential care purposes as joint, even when a contracting out agreement is in place. An example here is a couple in a second relationship, both wanting to protect assets for their own children. The husband develops an illness where he needs hospital level care, so he moves into hospital level care and the wife remains in the unit in the retirement village. Because their assets don't exceed the limits for eligibility for a residential care subsidy, they're required to pay for their care themselves. So that means that the ministry looks at not only his assets, but her assets as well, and they must use up joint assets until they reach the statutory limits. That can result in the wife losing almost all of her assets in residential care costs and creates very unjust situations. The situation has not yet been challenged through the courts, and we will have to wait until we have somebody with the funds and energy to appeal a ministry decision until we can have that situation reviewed. Now, the next thing I want to talk about is wills and enduring powers of attorney. Almost every retirement village requires residents to have current wills and enduring powers of attorney for property and for personal care and welfare in place prior to moving in. That means that there is somebody available to make care decisions should the person lose capacity, and the rest home has somebody they can approach to recover their costs should that be necessary. We find that quite often attorneys are signing occupational rights agreements, particularly when the residents are frail and perhaps don't have a good understanding of a residential care contract. If a person already lacks capacity and doesn't have enduring powers of attorney in place, the option is to make an application to the family court for the appointment of welfare guardians and other property managers or property managers. So what we need to look at is making sure that our clients have enduring powers of attorney in place well before they need them, because the applications for the court certainly cost considerably more than putting enduring powers of attorney in place, and they need to be renewed approximately every 3 years, which just adds to the cost. What I've done here is covered a few of the fissures that can be encountered when working with clients on residential care applications and residential care subsidies. It's certainly not all encompassing, and what we find is that the best results are achieved when clients, financial advisors, accountants and lawyers work together and start planning early. So my recommendation is that where you have older clients, that a roundtable discussion with all of the advisors working together will often produce the very best outcome for your clients, our clients, and certainly is what we as lawyers would like to see happen more often than it currently is. Thank you.